And you are Mr. Aquinos?
Yes,
Okay.
Your Honor.
Okay.
Aquino.
Aquino, pardon me. Okay, so Mr. Aquino does appear with Ms. McClurg. The issue that you raised is two things. The amendment, anything you wish to add to what you filed or that has been said by any of the lawyers, Mr. Bowe, Ms. Hamill, this afternoon?
Yes, Your Honor. I just want to, I guess, highlight some of the factual differences in our particular case. For the citation that was actually issued to Ms. McClurg, where on the citation it's supposed to indicate what statute, ordinance, or rule is actually violated. There's just a series of numbers. There's no indication whether it's a statute, or ordinance, or a rule. So on its face, it's just not valid, and that was the basis of our motion to dismiss. The response of the state was, well, don't worry about that because we filed something else, actually. We filed this other document that turns out was a different citation. It's one of the whiteout citations. And that citation combined, we sent your client a letter. That letter, which we won't deny our client received, also does not refer to the proper statute or administrative rule that authorizes the forfeiture. It does say that there's administrative code violation 2.14, but there are many chapters in the administrative code. It doesn't specify that it's one of the Department of Administration rules. And I think it's telling that the state only spends a paragraph defending this whiteout practice, doesn't cite any law, and says for the balance of its argument in its response brief is assuming argument, though, that the court invalidates this amendment, we're allowed now to work, that the court invalidates what they euphemistically call a pre-filing amendment, which is really their physical alteration of the citation. So we should now be allowed to amend the citation. Well, that, Your Honor, skips a step because there's a question of whether the court ever has obtained personal jurisdiction over Ms. McClurg because the court has failed to, the state has failed to comply with the procedural citation requirements. And I would, I guess, amplify what Attorney Loeb said, that the standard here is personal jurisdiction. It's not prejudice. I would point the court to the line of civil procedure cases, starting with American Family and its progeny, which is cited in our reply brief, where the court makes a distinction between procedural problems with the service and filing of a summons and complaint versus more what we call technical defects with the contents of the summons or complaint. So, American Family case, the court says what happened in the American Family case is that the defendant was not served with an authenticated copy of the summons and complaint. It was an unauthenticated copy of the summons and complaint. So there's all that was different between what was filed in court and what the defendant received was the clerk's stamp. There was no question that they were identical. It was photocopied. It just didn't have the clerk's stamp that was authenticated. The court said, sorry, we strictly apply these procedural rules because that's it's important for the orderly administration of justice that we have these procedural rules and that they be followed to a T. And this, those same principles apply in these forfeiture citation cases. The specific statute cited in the brief 778.25, paragraph 1b, says that in order for the court to have personal jurisdiction, the court has the citation following the form requirements in that section has to be issued to the client or issued to the defendant and filed with the court in order for the court to have personal jurisdiction. So I would draw a parallel to that American Family line of cases and say that without them following those procedural rules, the court simply doesn't have jurisdiction. And when the court doesn't have jurisdiction, its only authority is to dismiss the case. So I don't think we get to the question of whether the rules of civil procedure authorize a motion to amend a citation. But I do want to address that point. I addressed it in the brief, just want to add 2 points. One, the Peterson case that the state relies upon, in that case, an actual summons and complaint was filed to initiate that forfeiture action. That is an option under Chapter 778. You don't have to file it or initiate a forfeiture action with a citation. You can initiate one with a summons and complaint under 778.02. They didn't do that here. It's a citation. So the Peterson case is not applicable. And the other point I would add to my brief is that the state hasn't actually filed a motion to amend the citation. They just, in their response brief, say, hey, we should be allowed to amend the citation now. Attached is a proposed order to amend the citation. So, other than that, adopt the arguments of prior counsel.
Okay, Mr. Aquino, thank you. Just a couple of factual questions here for Ms. McClurg. Ms. McClurg, you heard earlier Mr. Bell's case. He got that letter that went out a couple of weeks after the citation here. In your case, the citation was the 26th of July, so August 14th, they sent you a letter talking about the change from V to VM. Do you know what letter I'm referring to then?
Yes, I do.
And could you speak into the microphone, please? And did you receive that letter?
I did receive that letter.
Okay. Did you receive a citation with that letter that reflected any change?
No, I did not.
Did you receive anything with the letter?
No, I did not.
And the original citation you got just said 2V?
It's the copy is attached to my brief, Your Honor. So you can see.
It's a little hard to read that, but it looks like it just says V. So that's
What
it says?
Right, it says 214, open paren 2, close paren V.
Okay. So I know you say it's not important, and you should just bear with me a minute. Was Ms. McClurg prejudiced by deeming this amended to charge the VM violation if we do that?
Well, only prejudice in the sense that we've had to go through this whole process to figure out what exactly Ms. McClurg has been charged with properly. And prejudice in the sense that everyone who has to deal with this departure from the procedure that is actually allowed by the statute. Prejudices everyone who's involved in the system because it slows things down. So in terms of going forward, probably not, because this is just the early stages of the proceeding, but certainly having to go through this process, and it's almost been, 6 months actually already since, or 5 months since citation.
Okay, well,
that's a form of prejudice, I would suppose.
Well, we've been dealing with these cases generally for about 6 months, but whether it was charged out under V or VM, let's say we never had this whole issue about the change in the citation and the letter. It doesn't really affect the merits of the arguments, right? I mean, it just seems to me I'm having a hard time understanding how, if it's relevant, how she was prejudiced by the state's asking me to amend this to charge VM.
Well, it's, yeah, I would just reiterate, it's the waste of time, and in any case, but that's, again, that's retrospective, not prospective, I understand.
Well, there would be a waste of time, and maybe this is what has to be done, but you agree that they could just issue a new citation, charge the VM, file it here, send it to her, and we'd be good, and we'd start this process again. They could do that.
If they decided that that's what they want to do, I think that's up to the state to decide what its policy is for issuing the citations. And, I'm not going, it's not for either of us.
Okay, fair enough. Thank you, Mr. Aquino. Ms. Weezy, anything further?
No, Your Honor.
Okay, thank you very much as well for your briefing, and I will also decide this in accordance with the others, Mr. Aquino and Ms. McClurg. So you want to seat then?